Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Where are we today? Come on, you guys know where we are. We're on the beautiful campus of Washington State University over here in Pullman, Washington. Listen, driving across the state yesterday with Gun Law Jr., geeking out on SCOTUS blog when the ruling in Trump v. Casa came out. And this had to do with nationwide injunctions, so we were all paying very, very careful attention to it. And we're going to go through the ruling because the Supreme Court has kind of put an end to that insanity. But it appears we got ourselves a pretty good cat fight brewing at the United States Supreme Court as well. We'll explain it all in just a moment. So today, let's spend a few minutes and let's talk about the Supreme Court says no more nationwide injunctions. Okay, America, the issues that we're talking about today have to do with birthright citizenship and the Judiciary Act of 1789. The case we're talking about is the recently decided case by the United States Supreme Court of Trump v. Casa. The majority opinion is authored by Justice Amy Coney Barrett. I know many of you are lukewarm on Justice Coney Barrett. I think when you have an opportunity to see how she took apart one of her fellow justices, y'all might become bigger fans of hers. Now, just to give you an idea of what this is all about, this was not about the constitutionality of Trump's executive order. This had to do with 3 nationwide injunctions that had been issued. And to give you an idea of what a problem and a recent phenomena this nationwide injunction is, I want you to consider this. There are 95 district courts in the United States. There have been 40 nationwide injunctions issued against the Trump administration so far, but 35 of those come from only 5 districts. You know, Maryland, Washington, California, New Jersey, New York, they go out and they venue shop to the most liberal jurisdictions, and these judges are essentially usurping the power of the executive branch. So the true constitutional crisis in America right now is the Article 3 branches of government invading the province of Article 2 branches of government. So just so you understand what the core issue was, it was not about the legitimacy of President Trump's executive order. No, it was about the legitimacy of the 3 nationwide injunctions. And as Justice Coney Barrett correctly framed the issue, the question whether Congress has granted federal courts the authority to universally enjoin enforcement of an executive or legislative policy plainly warrants our review, as members of this court have repeatedly emphasized. And in a very long and wordy opinion, Justice Coney Barrett does an excellent job of going through the history of the Judiciary Act of 1789, taking a look at other courts of equities to see, have we ever allowed small independent district courts to issue nationwide injunctive relief? And of course, the answer is no, we haven't. And that ultimately leads the majority to rule as follows. The bottom line: the universal injunction was conspicuously non-existent for most of our nation's history. Its absence from 18th and 19th century equity practice settles the question of judicial authority. Now, some of the analysis that the court had to undergo here was a historical-like analysis similar to what we do in certain Second Amendment litigation pieces, which is, has there ever been a historical precedent that allowed a district court or court of equity to issue nationwide relief, even to those who weren't asking for that relief? Ultimately, one of the things that the defendants here, those that were defending these nationwide injunctions, were using is, hey, there was a thing way back in the day in the courts of equity called the Bill of Peace. And the Bill of Peace would, in fact, actually allow relief to large classes of individuals. Oh, sounds very similar to a class action suit, doesn't it? Yeah, that's what the Supreme Court said as well when they ruled the Bill of Peace lives in modern form, but not as the universal injunction. It evolved into the modern class action, which is governed in federal court by Rule 23 of the Federal Rules of Civil Procedure. And so the big winner from the ruling of the United States Supreme Court in Casa v. Trump is, in fact, the class action lawyers. Because what the court is saying is, hey, listen, if you want to get nationwide relief moving forward, or if you want to get relief for large swaths of population beyond that that's actually named in the complaint, you're going to have to certify the class. And there is a very, very particular way in which a class must be certified before a federal court will accept it as a class action suit. That's all outlined in Rule 23. Now, that has some very good and positive implications for us today, but we're going to circle back on it in a moment because it could actually have some pretty devastating consequences. So I want you to know that even though a lot of you are really happy about the way the opinion came down in this case, it could come back and bite us at a later time. But it is clear from the court's directive that if you want to actually have large nationwide relief, you're going to have to certify a class, because the court has ruled Rule 23's limits on class actions underscore a significant problem with universal injunctions. A properly conducted class action, we have said, can come about in federal courts in just one way, through the procedure set out in Rule 23. And for all the parties who are saying, but we need complete relief comes from granting relief to the people who have asked for it. As Justice Coney Barrett correctly puts, complete relief is not synonymous with universal relief. It is a narrower concept. The equitable tradition has long embraced this rule that courts generally may administer complete relief between the parties. And again, it comes down to the simple concept that the only parties who can get relief from the court are the parties to the lawsuit. And ultimately, with the complete lack of history, with the fact that this is just a modern judicial usurpation of the Article 2 branch of government, the majority opinion correctly rules nothing like a universal injunction was available at the founding, or for that matter, for more than a century thereafter. Thus, under the Judiciary Act, federal courts lack authority to issue them. And so goes it. Now, listen, there's 119 pages to this opinion, and that's because every justice wanted to weigh in one way or the other with concurring or dissenting opinions. But the dissenting opinion that stands out the most, and we have said time and time again, that Justice Ketanji Brown Jackson is clearly way in over her head. And when you read her dissenting opinion, which of course will be linked up down below, so you don't have to take our word for it, you can geek out on it for yourself, you will see that this is a justice who actually believes that an Article 3 branch of government is in fact the emperor for all. And Justice Coney Barrett, in a very rare move, takes significant, and I do mean significant, swipes at Justice Coney Barrett and comes about this close to just calling her a frickin' idiot. I'm not joking. And this is what really kind of got me excited again about Justice Coney Barrett, because this is a brutal takedown. Consider all of this. The principal dissent focuses on conventional legal terrain like the Judiciary Act of 1789 and our cases on equity. Justice Jackson, however, chooses a startling line of attack that is tethered neither to these sources nor, frankly, to any doctrine whatsoever. Waving away attention to the limits on judicial power as mind-numbingly technical query, she offers a vision of the judicial role that would make even the most ardent defender of judicial supremacy blush. In her telling, the fundamental role of courts is to order everyone, including the executive, to follow the law, full stop. Oh, but you see, Justice Coney Barrett was just getting warmed up. Rhetoric aside, Justice Jackson's position is difficult to pin down. She might be arguing that universal injunctions are appropriate, even required, whenever the defendant is part of the executive branch. If so, her position goes far beyond the mainstream defense of universal injunctions. And then finally, in dismissing Justice Ketanji Brown Jackson's dissent altogether, the majority opinion authored by Justice Coney Barrett specifically states, "We will not dwell on Justice Jackson's argument, which is at odds with more than 2 centuries worth of precedent, not to mention the Constitution itself. We observe only this. Justice Jackson decries an imperial executive while embracing an imperial judiciary." Now listen, it is very common for judges to take shots at some of the logic behind other judges' dissenting or concurring opinions. But this portion of the opinion is really about this close to an absolute takedown of Justice Jackson's intellect, which I think we all have to be asking ourselves how much of that is truly there. But here's the cautionary tale that I want you all to understand, America, because we always, every time we think something is totally awesome, this is great, we have to ask ourselves, what happens if it's applied the other way? And so I want you to, again, go in your time machine and go out into the future sometime where we have like a President Gavin Newsom, and we have an Attorney General who's as bad, if not worse, than Rob Bonta. And now we are getting executive order after executive order that is basically suspending the Second Amendment rights of American citizens everywhere. That we have assault weapon bans or magazine bans or universal background checks all being implemented not by legislation, but instead by executive orders. And now we want to start filing suits to challenge that. Well, you recognize now that under the rulings of Casa v. Trump, unless we certify an entire nationwide class under Rule 23, the relief that's granted in any of those lawsuits will only be for the named plaintiffs. And sure, we might have groups like the National Association for Gun Rights or Second Amendment Foundation, GOA, any of those other very worthwhile organizations, and it might include members of their organization. But for all lawful and responsible gun owners nationwide, where the executive order is inflicting damage upon them, they will not receive relief unless they file their own lawsuit. So listen, for the here and now, this is a good thing because this will allow President Trump to actually execute his agenda, which the American people asked for through the election. But mark my words, America, there's going to be a time, maybe a few years from now, maybe a couple of decades from now, where the shoe's going to be on the other foot. And we are going to want a nationwide injunction against something that is absolutely and blatantly unconstitutional. But we're going to have to then slug through dozens and dozens of lawsuits before we can actually obtain the remedy which is properly deserved. Listen, a very important case, a very interesting case, and I think an outstanding opinion authored by Justice Coney Barrett. The case, once again, is Trump v. Casa. You don't have to take our word for it about what it said because we're going to link it all up down below so you can geek out on it for yourself. Now listen, if you got any other questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now, but if you don't, that's okay. That information's down there in the description box. Maybe you got an idea for a video we should be doing around here. Cool. Click on that link right there and tell us all about it. If you want to subscribe to the monthly newsletter, the ability to do that is down there in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. From the beautiful campus of Washington State University, thanks for watching and stay safe.